Hey, this is Ben Freer. I'm an immigration lawyer for entrepreneurs, and today I'll discuss the topic of national interest waivers for startup founders. In my practice, I typically handle E2 visas because, quite frankly, for most of my clients, this visa is a perfect fit. After all, the E2 visa enables entrepreneurs to come to the US to direct and develop a business in which they've made a substantial at-risk investment. And this is exactly what most of my clients want to do. But despite its benefits, the E2 visa is not great for everyone. For example, a lot of talented entrepreneurs won't qualify simply because their country of nationality does not have an E2 treaty with the United States. Other founders will not qualify as E2 investors because they own less than 50% of the business in which they've invested. And even if a particular entrepreneur qualifies for the E2 visa, it makes sense to put some thought into the national interest waiver green card option, assuming that they want to stay long-term in the United States. Okay, so let's talk a little bit about the basic requirements so you can do a self-assessment before you reach out to an immigration lawyer. After learning about some of the details, many people quickly come to the conclusion that the national interest waiver isn't a great option for them. But you never really know until you look at the requirements. So let's jump right in and talk about some of the things that founders should know about this option. The first thing I'm going to talk about isn't really a requirement at all, but it is something that I suspect will turn off a lot of people right away. If you were to decide to file for national interest waiver green card, you would spend a few months to gather all the necessary documentation and complete the required forms. Then, after everything is perfect, you would mail your evidence to USCIS. After submission, you would wait and wait and wait. Since premium processing is not currently an option, you may have to wait 12 to 24 months to get a response from the US government. Now, for those of you who aren't completely scared away by that unfortunate reality, let's move on and talk about the requirements of national interest waivers for startup founders. To satisfy the first requirement, you must show that you have exceptional ability or a master's degree or a bachelor's degree plus 5 years of progressive experience in your field. As you can imagine, demonstrating the attainment of a master's degree is pretty straightforward. Demonstrating exceptional ability, on the other hand, is a little more challenging. Exceptional ability can be demonstrated by any of the three following types of evidence: an academic record showing a degree, diploma, certificate, or similar award relating to the area of exceptional ability, letters from current or former employers documenting at least 10 years of experience, a license to practice a profession or certification for a profession or occupation, evidence of a high salary compared to others in the field, membership in a professional association, recognition for achievements and significant contributions to the industry or field by peers, government entities, or professional or business organizations, or comparable evidence if these categories do not apply to your situation. Now, obviously, it's best to avoid having to make this type of showing. So entrepreneurs with a master's degree or the equivalent are at a distinct advantage over those who have to do the heavy lifting of proving exceptional ability. For those of you who have the proper educational background or confidence in your ability to demonstrate how you are exceptional, then it's time to look at the three-pronged test for the national interest waiver that is articulated in the landmark case called Matter of Donisar. For the first prong of the test, you must show that your planned endeavor has substantial merit and national importance. Substantial merit typically isn't much of a challenge for startup founders since job-creating business endeavors are generally considered to be beneficial. Unfortunately, proving national importance is a little bit more difficult. This requirement can be met if an undertaking is expected to have national or even global implications, or it is anticipated to have a huge impact in a particular field. Now, entrepreneurs like to point to job creation to meet the national importance requirement. But while job creation is great, especially if it's substantial, if you can show that your startup brings a broader benefit to the American public, you will strengthen your case and improve your chances of a successful application. In addition to proving that your endeavor has substantial merit and national importance, you will also need to prove that you're well positioned to advance the proposed endeavor. In the startup context, the following questions will be considered by the government to determine if a founder meets this requirement. Does your unique combination of experience, education, and knowledge put you in an ideal position to advance the startup? Have you succeeded in similar efforts? Can you demonstrate your past success through media, awards, etc.? If so, the government will be more likely to conclude that you're likely to succeed with your current endeavor. Has the startup made any significant progress? For example, do you have customers? Can you demonstrate substantial growth? Has the company attracted investments from venture capital? Has the startup received support from incubators or accelerators? Have the relevant patents been secured? In other words, is the business doing well at this stage? And have you played a central role in the company's early success? For the final requirement, you have to prove that on balance, it is beneficial to waive the job offer and labor certification requirements that are typically associated with employment-based green card applications. Now, I won't spend much time on this one. Meeting the national interest waiver requirements is extremely difficult, but fortunately, it is typically fairly easy for founders to satisfy this last requirement. There are a few reasons why this is the case. First of all, the standard employment-based green card process requires an employer to look for a minimally qualified worker through the labor certification process. When you're talking about a startup that has national importance, you don't want someone who's minimally qualified. You want the best person, typically the founder, to be in a position to move that company forward. And perhaps the best and most elegant argument is simply that entrepreneurs are not a good fit for the standard labor certification process. With regards to labor certification, DONASAR, which is the landmark national interest waiver case, states it, meaning labor certification, has proven particularly ill-suited for USCIS to evaluate petitions from self-employed individuals such as entrepreneurs. So there you have it. I hope you enjoyed this discussion on national interest waivers for startup founders. Now that you have this information, you can think about this path in light of your own unique situation. And if you decide this could be a decent option for you, I encourage you to reach out to one of the many amazing US immigration lawyers that you can find across the globe. If you did find this video to be helpful, please like it or pass it along. Thanks for your time.